Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officials, listener, learners. The Most Honorable President Prime Minister Modi ji, respected doctors and directors, I welcome all adorable ministers and managers. I welcome all honorable advocates, supervisors, administrative advisors. It is really nice time, nice place, nice section that we are going out Holy Indian international constitutional laws and human rights. Sanctioned in international law, there is great controversy among the jurists in regard to the sanctions in international law. It has already been pointed out earlier that there are two extreme viewpoints in this regard. According to one point, there are no sanctions at all behind the international law. In accordance with the second viewpoint, even if it is admitted that there are no sanctions behind the international law, it can be included in the category of law because sanction is not an essential element of law. In between these two extreme views, some authors hold the view, and rightly too. It is it is wrong to say that international law is without sanctions. As aptly remarked by Joseph L. Kunz, legal sanctions constitute the reaction of the legal community against a delict, in contrast to disapproval by the members of a community as a moral sanction. Legal sanctions are socially organized measures in contrast to the transcendental sanctions on religious norms. They are to be applied against or without the will of person against whom they are directed. They are finally to be applied by physical force if necessary. In the view of Kelsen, the disguising feature of law is that it is a coercive order. The rules of law be corrected with a sanction from the viewpoint even of the legal system. Force must be either a sanction or delinquency. In the international field, sanctions exist in the form of war and repression. The difference between the municipal law of states and international law would consist in the degree of Centralization as regards the use of force. Within the state, force is monopolized by the community. But in the society of state, illegitimate use of force may be made by the subjects of law. The individual states, as a matter of fact, it would be wrong to say that there are no sanctions at all behind international law, although it is true that as compared to municipal law, the sanctions of international law are far less effective. Starkey has pointed out the following sections behind the international law. One is under Chapter 7 of the United Nations Charter. If there is threat to the international peace and security, or an aggression has taken place, the Security Council can take necessary action to maintain or restore international peace and security. In this way, to some extent, the violation of international law can be checked and necessary action can be taken for maintenance of peace and security. Two is the decisions of the International Court of Justice are binding upon the parties to the dispute. Article 94 of the United Nations also provides that if a party to the dispute does not follow the decision of the court, the other party may approach the Security Council, which can take necessary action, necessary measures to ensure the implementation of the decision. However, it cannot but be admitted that the UN Charter does not contain any provision to maintain international law generally. Three is under Article 2.4 of the chapter. The members of the UN have undertaken that they shall respect the territorial integrity and political independence of each other and shall not use force against each other. There is only one example in the Charter wherein the members may use force. That is contained under Article 51 of the Charter, which confers on the members the right of individual and collective self-defense. But even this right can be exercised only when an armed attack has been taken place and is subject to overall supervision and control of the Security Council. But a pertinent question arises as to whether international law can be maintained without strong coercive mechanism. As aptly pointed out by Soviet authors, such mechanism exist in principle. For example, the powers of the Security Council and Chapter 7 of the UN Charter. They should of course be set in motion whenever necessary. However, in the longer run, it is nevertheless impossible to count excessively on these mechanisms the application of which is hampered in practice and which have so far proved to be only marginally effective. Further, a reasonable world order, an order reflecting a balance of interest, can be maintained with a minimum of caution. First of all, there arises in this context the matter of effective mechanism for control over compliance with the international treaties. Another area in the efforts to strengthen law and order is the use and upgrading of the mechanisms of peaceful settlement of disputes. Thus, international law is not without sanctions, although these sanctions are not generally for the enforcement of international law in general. These sanctions are to maintain or restore international peace and security, which is only a part of international law. As pointed out by Joseph L. Kunz, a more advanced international law must be based on the full recognition by states of the primacy of international law and enforceable sanctions both for the maintenance of peace and security and for the enforcement of sanctions both for the maintenance of peace and security and for the enforcement of international law in general by organs of international community. While welcoming the President of India to lay the foundation stone of the building of Indian Society of International Law, Justice Nagendra Singh aptly remarked, according to our ancient concept of law, the eternal, the element of sanction provided by the authority of states, sanctions provided by the authority of state is inherent in law itself to such an extent that without ostensible demonstration law has a halo of respect behind it and everyone has to learn to ever respect it. Manu said, Dand Dharam Vidurghatam. Dand Dharam Vidhurtam. This is equivalent to saying that law itself has an inbuilt element of respect and sanction behind it, and wise men brings in their own interest need not search to authority to obey law as all laws are ordained to be obeyed. The position of international law is sometimes like Manu's concept in this respect that there is no ostensible sanction or word authority in a building state. However, respect flowing from inherent utility is so embedded in the very concept of that branch of law that it compels obedience to the precepts and tenets of international law. It cannot be denied that international community does not possess any well-organized force or machinery to force international law generally. Despite this, whatever sanctions there are behind international law make impact upon the states and in practice states generally follow international law. International orders, far from perfect though it has its own sanction, seldom imposed by force or command, but as it were, national sanction slow to mature and gradual in effect but made compelling by the growing interdependence of the world. In fact, there exist among states rules imposing obligations upon them. According to Stark, If the word sanctions to be taken in the larger sense measures, procedures and expedients for asserting pressures upon a state to comply with its international legal obligations, then the above mentioned provisions of the United Nations Charter are not exhaustive of the sanctions which may become operative in different areas of international law. He cites several illustrations. One is the Constitution of ILO lays down a procedure for dealing with complaints regarding failure of a member state to secure the effective observance of an international labor code. Two is Article 14 of the Convention on Narcotic Drugs 1961 provides that if a party to the conventions fails to carry out the provisions of the convention, the International Narcotics Control Board is entitled to call for explanations, and if the explanation is unsatisfactory, the board may call the attention of other competent UN organs to the position and may even recommend a stoppage of drug imports or exports or both to and from the country or territory in default. 3 is under Article 54 to 55 of the 1965 Convention on the Settlement of Investment Disputes between states and nationals of other states. Each contracting state is to recognize an arbitral award made pursuant to the convention as binding and is to enforce the pecuniary obligation imposed by the award as if it were the final judgment of a court in that state. For his act by acts by a particular state in violation of international law may sometimes be regarded by the states as invalid and inoperative. Reference may be made to the advisory opinion of the World Court on the legal consequences for states of the continued presence of South Africans in Namibia, Southwest Africa, wherein the court held that South Africa's presence in Namibia was illegal and that the members of the UN were under obligation to recognize the invalidity of South Africa's acts in respect of Namibia and should refrain from such acts as may imply acceptance of the legality of the presence in and administration of Namibia or lending support to these. Numerous other sanctions exist under the constituent instrument of different international organizations such as ICAO, WHO, ILO, UPU, ITU, etc. These have been briefly discussed in Chapter 1 under the heading Development of International Law by International Organization. In this chapter, it has already been pointed out that there is a special mechanism by which the ILO functions to evaluate its standards. It may be added here that together the whole body of ILO constitution and recommendations which the ILO considers still in effect is commonly known as International Labour Court. This court and the organization have an impact far beyond the number of states which have ratified each convention. In order to ascertain the convention's impact, it is important to take into account that the member states which have not ratified constitution yet have altered their laws or practice in response to the principle established by the ILO, often as a result of sophisticated ILO system of monitoring its standards. Furthermore, national courts as well as national legislation also relies on the ILO's articulation of legal principles, especially as the area of collective bargains and freedom of articulation on which the organization developed a large number of precedents. Reference may also be made here to Article 26 of ILO Constitution, under which any of the members may file a complaint with the ILO office if it is not satisfied that any other member is securing the effective observation of any convention which both have ratified. The governing body may, if it thinks fit, refer the complaint to the Commission of Inquiry. After the Commission makes a report under Article 26, the Director General shall communicate report to the governing body. Further, each of the governments within 3 months shall inform the Director General whether or not it accepts recommendation contained in the report of the Commission, and if not, whether it proposes to refer complaint to the International Court of Justice. If governing board finds failure, it shall refer to the General Conference. Finally, if the matter is referred to the International Court of Justice, then under Article 31, the decision of the International Court of Justice in regard to the complaint of matters which has been referred to, it is pursuant of Article 29, shall be final. Similarly, under Article 37 of ILO Constitution, any question or dispute relating to the interpretation of the Constitution or of any subsequent convention concluded by members shall be referred for the decision of the International Court of Justice. Advisory opinion of the International Court of Justice shall be binding upon any tribunal. Dispute settlement mechanism under the WTO also deserves mention here. It has been aptly pointed out an emerging system of sanction for the enforcement of international law is discernible. There are also certain other indications of a growing maturity in the international legal order. These include the recognition of certain rules that have the Charter of Just Cogence, which dash establishes that within the general body of rules of international law there exist superior legal rules, with which rules of a law order must be compatible. Apart from the above sections, other factors such as adverse public opinion, expediency, possibility of imposition of economic sanction, fear of suspension or breaking of diplomatic relation, possibility of referring the matter or dispute to the UN or specified agencies of the UN, fear of suspensions or expulsions from the membership of UN or other international organization, fear of punishment of war crimes, fear of payment of reparation, etc. also operate as sanctions behind international law. Indeed, the most important of these sanctions is public opinion, which is the ultimate sanction behind international law and, for that matter, behind any law, basis of international law. After having arrived at the conclusion that international law is law in the true sense of the term, it is necessary to see as to what is the true basis of international law. There are two main theories in this connection. They are: one is theories as to law of nature, two is positivism. Theories as to law of nature. The jurists who adhere to this theory are of the view that international law is a part of the law of nature. In their view, states follow international law because it is a part of the law of nature. Explaining the viewpoint of natural law theorist Stark has written, states submitted to international law because their relations were regulated by higher law, the law of nature of which international law was but a part. In order to understand this theory, it is necessary to understand the meaning of law of nature. In the beginning, law of nature was connected with religion. It was regarded as the divine law. The jurists of 16th and 17th centuries secularized the concept of law of nature. Much of the credit for this goes to the eminent jurist Grotius. He expounded the secularized he expounded the secularized concept of the law of nature. According to him, natural law was dictated of right reason. His followers applied the law of nature as an ideal law which was founded on the nature of man. As a reasonable being, international law was considered binding because it was in fact natural law applied in special circumstances. Vattel, a famous jurist of 18th century, also expressed the view that natural law was the basis of international law. Poffentori, Christian, Thomasius, etc., are other prominent exponents of law of nature. In its criticism, the exponents of natural law are of the view that it is the basis of international law and has conferred binding force on international law. It may, however, be noted that each follower of the law of nature gives its different meaning. They use it as a metaphor. Different jurists give its different meanings such as reason, justice, utility, general interest of international community, etc. Hence, the meaning of law of nature is very vague and uncertain. Moreover, the main defect of this theory is that it is not based on realities and actual practices of the states. In its influence, despite the above criticism, the law of nature has greatly influenced the growth of international law. Traces of natural law theories survive today, albeit in a much less dogmatic form. The ideal nature of the natural law has also greatly influenced the growth of international law. Positivism. Positivism is based on Positivism is based on law positivism, that is, law which is in fact as contrasted with law, which ought to be, according to the positivism, law enacted by appropriate legislative authorities binding. The positivisms the positivists base their views on the actual practice of the states. In their view, treaties and customs are the main sources of international law. The positivists' view that was in vogue in the 18th century. Banker Shaikh, one of the chief exponents of the positivist school, wrote several books to popularize his views. In the view of the positivist, in the ultimate analysis, will of the state is the main source of international law, as pointed out by Stark. International law can, in logic, be reduced to a system of rules depending for their validity only on the fact that states have consented to them, as pointed out by Brierley. The direction of positivism teaches that international law is the sum of rules by which states have consented to be bound, and that and that nothing can be law to which they have not consented to be bound. The concept of the will of state was first propounded by the German philosopher Hegel. According to the positivists, international law is a body of rules which has been consented to by the states and accepted as binding by way of voluntary restriction of auto limitation. The Italian theorist Angiolotti, one of the chief exponents of the positivist school, deserves a special mention. According to him, the binding force of international law is founded on a supreme principle or norm known as pacta sunt servanda. In his view, the basis of each rule of international law is pacta sunt servanda in some or other way. The positivists admit that their view fails to explain the basis of customary international law. In their view, there is an implied consent in regard to customary rules of international law. In its criticism, the positivist theory is based mostly on the actual practice of states, but this view has been subjected to a lot of criticism. It can be criticized on the following grounds. One is the concept of the will of state presented by the positivist is purely metaphorical. Two is the view of positivists that the whole of international law is based on the consent of the state is far from truth. As pointed out by an eminent author, custom is said to be evidence of a general practice accepted by law. It is not required. It is not required that there should be any express recognition by states in order that this practice or international custom shall be binding upon them. The extreme positivist view which seeks to base all international law on the consent of states has tried to establish that the rules of international custom are based on tacit agreements between states. But in reality, it is not possible to prove that these rules come into existence in such a way. This is shown by, among other things, the fact that a new state entering the community of nations at once becomes bound by the international customary rules, and it is suggested that any of these rules would not be binding on it. It never happens that the state consent is sought or that it enters into any agreement on the matter with the already existing states. On the other hand, the new state is not bound by any international convention already in force unless it expressly adheres to it. International custom constituents general international law, area law for the society of states. From this, it follows that the dictum pacta sunt servanda cannot be the basic norm of international law. It is itself a rule of international custom. Three is, in practice, it is not always necessary to show that in regard to a particular rule of general international law, the state had given their consent. For instance, there are some principles of international law which are applicable on states, although states did not give their consent for them. The principle propounded under Article 2.6 provides that the organization shall ensure that states which are not members of the UN act in accordance with the principles contained in Article 2 of the Charter, so far as may be necessary for the maintenance of international peace and security. The norm Pacta sunt servanda has been abandoned by most theorists, since it seems incompatible with the fact that not all obligations under international law arise from pacta. However widely that term is construed, so it has been replaced by some something less familiar. The so called rule that states should behave as they customarily have. Six is, even apart from its lack of accord with reality, the theory that international law insists on agreements is problematic in another respect. Declarations of will are, of course, in themselves pure facts which have legal effects only because some rule of law gives them such effects. 7. According to the positivist view, treaties and customs are the only sources of international law. Grotius made distinction between the jus gentium, the customary law of national, which he called jus voluntarium or voluntary law, and jus naturia or natural law of nation. He concentrated more on the natural law and regarded voluntary law of less importance. The Gaussians were somewhat between the naturalist and the positivist. They maintained the distinction between natural and voluntary law of nations, but they considered positive or voluntary laws of equal importance to the natural laws. Thus, according to the Gaussians, international law has originated not only from customs and treaties but also from natural law. This view obviously is not in conformity with the positive view. The positivist view that treaties and customs are only sources of international law is also not in conformity with Article 28 of the Statute of International Court of Justice, according to which general principles of law recognized by civilized nations are also the sources of international law, as pointed out Manley O. Hudson. The provision relating to the general principles of law recognized by a civilized nation serves a useful purpose in that it emphasizes the creative role to be played by the court. In it confers such a wide freedom of choice that no fixed and definite content can be assigned to the term employed. It has widely hailed as a refutation of the extreme positive conception of international law. Influence and contribution. Despite the above mentioned defects and criticisms, a great merit of this theory is that it is based on the actual practice of the states. It emphasizes that only those rules are the rules of international law which have been adopted by the states and are observed in practice. Yet another special feature of this theory is that it has encouraged realistic outlook in international law. In several cases concerning the customary rules of international law, the International Court of Justice has adopted the positivist attitude. The Ashram case, the Anglo-Norwegian fisheries case, and the rights of the U.S. nationals in Morocco cases deserve special mention in this connection. In the Aslam case, the International Court of Justice observed the party which relies on a custom of this kind must prove that this custom is established in such a manner that it has become binding on the other party. The Colombian government must prove that this rule invoked by it is in accordance with a consent and uniform usage characterized by the states in question and that the usage is the expression of a right ascertaining appertaining to the states granting asylum and is a duty incumbent on territorial states. True basis of international law in the modern period. So, in the modern period, no state can keep itself aloof from the affairs of the world. The means of transport and communication and other scientific inventions have brought the states of the world closer to each other. The practices of states are therefore of great significance As pointed out, the positivists have greatly encouraged the realistic outlook in international law, have thus rendered a signal service. However, no specific theory is capable of explaining the true basis of international law. Indeed, no single theory has received general agreement and sanction. It appears as though there are as many theories as there are scholars. According to Sir Qasid Hurst, no state can escape from the influence of international law. He has rightly pointed out international law is in fact binding on states because they are states states. Thus states obey international law because they are states. States obey international law because it is in their interest to do so. The ultimate explanation of the binding force of law is that man, whether he is single, individual, or whether he is associated with other men in a state, is constrained in so far as he is a reasonable being. To believe that order and not chaos is the governing principle of the world in which he has to live. Moreover, as aptly pointed out in the ninth edition of Oppenheim's International Law, it is, however, in accord with practical realities to see the basis of international law in the existence of an international community, the common consent of whose members is that there shall be a body of rules of law, international law, to govern their conduct as members of that community. In this sense, common consent could be said to be the basis of international law as a legal system. Furthermore, this common consent cannot this common consent cannot mean, of course, that all states must at all times expressly consent to every part of the body of the rules constituting international law. For such common consent could never be established. The common consent that is meant is thus not